court move that caught both Trumps. The claims didn't arrive through a press conference or a breaking news banner. They resurfaced quietly through a lawsuit filed by author Michael Wolff, a legal action that pulled long dormant Epstein-related allegations back into the judicial record. On the surface, the case appeared narrow, focused on disputed statements and reputational harm. But beneath that surface, something more consequential was unfolding. This was never just about one individual. What made the lawsuit different wasn't the accusations themselves, it was the legal framing. Wolff's filing didn't treat the Epstein claims as isolated gossip or background noise. It placed them in a context, relationships, access, proximity, and credibility that courts are trained to examine differently than the media ever would. In that context, the question stopped being who said what and became who is connected to whom and how. That shift mattered. As attention returned to Donald Trump's past associations, another legal move entered the picture. Melania Trump filed her own court action, widely interpreted as an effort to draw a clean boundary legally and reputationally between herself and the allegations circulating around her husband. The intent appeared straightforward: distance, separation, clarity. A signal that whatever legal exposure existed, it was not shared. But in court, intent doesn't always control outcome. Lawyers noticed immediately that the filings created overlapping narratives. By asserting separation, Melania's legal team implicitly acknowledged the existence of a shared environment, shared timelines, shared social proximity, shared public identity, one in media terms cannot simply ignore. In media terms, separation is easy: issue a statement, draw a line, move on. In legal terms, separation invites scrutiny. Courts don't evaluate relationships the way headlines do. They look at proximity, benefit, knowledge, and context. Family proximity, in particular, is treated as a substantive factor, not because family members are presumed guilty, but because courts recognize that shared households, shared schedules, and shared public roles complicate claims of complete independence. A filing meant to narrow exposure can, paradoxically, widen the lens. Once multiple legal actions reference the same underlying narrative, even indirectly, judges and opposing counsel begin mapping connections. What was peripheral becomes relevant. What was background becomes context. On context is where legal risk often expands, not contracts. That's what caught both Trumps in the same frame. Not through accusation, but through structure. Not through allegation, but through procedure. And the law doesn't need to prove wrongdoing to justify broader inquiry, it only needs to establish relevance. And relevance grows when stories overlap, timelines intersect, and legal strategies collide. The Wolff lawsuit reopened a door many assumed had closed. The subsequent filings, instead of sealing that door, added rooms to explore. Each move, rational on its own, interacted with the others in ways no press strategy could fully control. This is the quiet difference between legal reality and public narrative. In public, separation is declarative. In court, separation is evidentiary. You prove it, line by line, under rules that don't bend to optics. That's the lesson embedded in this episode. A single legal response designed to create distance can create shared exposure instead. Not because anyone intended it, but because the law connects dots the public prefers to keep apart. In court, separation is harder than it looks. Why Wolff's lawsuit boxed them in? Michael Wolff is not a random provocateur in the eyes of the court. He is a published author with established access, documented sourcing practices, and a long public record of reporting on powerful figures. That matters legally. Courts don't assess claims based on popularity or tone. They assess them based on whether a plaintiff can plausibly argue that statements were made, circulated, and relied upon in ways that caused harm. Wolff's credibility as a chronicler of elite political circles gives his filings a procedural seriousness that casual commentary lacks. That seriousness helps explain Donald Trump's long-standing strategy toward Wolff: avoid direct engagement. For years, Trump has attacked Wolff publicly while steering clear of courtroom confrontation. The reason is structural. Direct legal engagement forces positions to be formalized. Allegations that are vague in media become specific in pleadings. Rebuttals that are flexible in interviews become fixed in sworn filings. Once something is placed on the record, it stops being a talking point and becomes a constraint. That strategy worked until it didn't. Her filing was widely interpreted as a personal effort to reject association with defamatory claims and protect her own reputation. On its own, that makes sense. But in a legal ecosystem, individual filings rarely exist in isolation. When related figures respond differently to the same underlying narrative, courts begin looking for consistency or the lack of it. Consistency matters more than denial. Courts don't simply ask whether a claim is denied. They ask whether denials align across timelines, relationships, and contexts. When one party asserts separation while another remains silent or evasive, the contrast becomes relevant. Not incriminating by default, but relevant enough to explore. And relevance is the gateway through which plaintiffs move. A denial by one party can affect another because it narrows the range of plausible explanations. It forces clarity where ambiguity once existed. If one filing asserts that certain claims are false or unrelated, opposing counsel will test whether that assertion is compatible with other known facts, statements, or omissions. If it isn't, the inquiry widens. That's the danger of locking in narratives too early. Public figures often rely on ambiguity as protection. Vague denials, shifting emphasis, and selective silence allow flexibility. But once a narrative is filed in court, flexibility disappears. Positions become evidence, and evidence becomes something that can be compared, contrasted, and challenged. Plaintiffs understand this dynamic well. They exploit overlap not by inventing connections but by highlighting them. Similar language across filings, shared timelines, parallel descriptions of events. Even differences can be useful because inconsistency invites examination. The goal isn't always to prove wrongdoing immediately, it's to justify deeper access to testimony and documents. Wolff's lawsuit boxed them in by forcing this transition from media management to legal posture. What could once be dismissed as noise now requires coherence. Each response or lack of one interacts with the others. And once the court begins treating a story as a single ecosystem rather than isolated claims, individual strategies lose their insulation. That's the central risk revealed here. In public, narratives can coexist, contradict, and fade. On court, they converge. The moment a story is formally filed, it stops belonging to its authors, its subjects, or its audience. Once a story is filed, it belongs to the court. When the Epstein shadow touches both, certain allegations never fully disappear. They recede, resurface, and wait. Epstein-related claims exist in that category, not because they are constantly proven, but because they are constantly contextualized. Each time a new lawsuit, filing, or sworn statement references the same network of names, the shadow returns, shaped less by novelty than by accumulation. That is why proximity matters. Michael Wolff's framing does not rely on new accusations. It relies on access and adjacency: who was present, who moved in the same circles, who occupied overlapping timelines. In legal terms, proximity is not guilt, but it is relevance. Courts are permitted to ask whether repeated references to the same relationships justify deeper scrutiny, especially when those relationships have already been publicly documented. Public visibility raises the stakes. Donald Trump's past visibility, photographs, interviews, social appearances, creates a paper trail the court cannot ignore, not because visibility proves misconduct, but because it reduces deniability. When associations are public rather than private, courts treat claims about them differently. The threshold for relevance is lower. The expectation of contextual inquiry is higher. This is where renewed scrutiny enters. Even if claims are old, repeated public references can revive them legally. Courts distinguish between a single allegation and a pattern of references that reappear across time and filings. When a plaintiff can show that a narrative persists, not just in rumor, but in formal statements, the court becomes more open to examining why. Melania Trump's filing unintentionally reopens that door. Her legal response was designed to assert independence and protect personal reputation. But asserting separation necessarily acknowledges shared context. It invites questions about what is being separated from what and why the distinction now matters. Courts do not interpret such filings emotionally, they interpret them structurally. If one party draws a boundary, the court may ask what lies on either side of it. Repeated public claims are treated differently than isolated ones. When the same names, events, or environments appear across books, interviews, lawsuits, and filings, courts recognize a continuity that media cycles often obscure. Each repetition strengthens the argument that the issue is not ephemeral. That continuity can justify broader discovery, even if the underlying intent was simply reputational defense. This is where legal risk expands beyond intention. Discovery does not require proof of wrongdoing, it requires relevance, and relevance grows when filings intersect. A court does not need to believe a claim to allow questions about it. It only needs to believe those questions are reasonable given the record. Once that threshold is crossed, control shifts from the subjects to the process. Indirect references matter because they connect ecosystems. A name mentioned in passing can pull in timelines, witnesses, and documents that were never the original target. Lawyers understand this. Plaintiffs use it strategically, not to accuse broadly, but to justify inquiry narrowly, step by step. Each indirect reference becomes a thread the court is allowed to follow. That is the danger of the Epstein shadow. It does not accuse, it contextualizes. It does not prove, it persists. And persistence in law carries its own weight. What looks like distance in public can look like proximity in court. What feels resolved can feel unfinished once formal filings reassemble the story. And when names recur together often enough, separation becomes harder to sustain. Some names pull others into the frame. Or instincts voices legal reality for years. Donald Trump has relied on a media-first defense strategy. When challenged, he responds loudly, quickly, and publicly. Statements are framed for maximum impact, designed to dominate the news cycle, discredit critics, and project confidence. In the world of television and social media, that approach often works. Volume can overwhelm nuance. Repetition can feel like resolution, but courts do not operate on those rules. Legal filings are not performances, they are records. Every word is weighed not for emotional effect, but for consistency, plausibility, and alignment with known facts. What sounds decisive on television can look imprecise on paper. What energizes supporters in interviews can become a liability when preserved in pleadings and compared against timelines and prior statements. That is the fault line exposed here. Trump's public posture toward Epstein-related claims has long been categorical denial, delivered with confidence and dismissal. In media terms, such certainty projects strength. In legal terms, absolute language narrows flexibility. It reduces the range of explanations available if new context emerges. Courts do not punish confidence, but they do test it. Melania Trump's response fits a different instinct. Her filing appears rooted in reputational defense rather than confrontation. It seeks to establish personal distance, to assert that certain narratives do not apply to her. From a public relations standpoint, that makes sense. Separation is clarity. Clarity is protection. The problem is that legal clarity often invites legal examination. Courts strip emotion from filings. They do not weigh outrage, indignation, or intent. They compare statements. They examine whether positions taken in one filing align with positions taken elsewhere. They ask whether the boundaries being asserted are supported by evidence or contradicted by context. Consistency, not confidence, is the governing principle. This is where strong denials can still create exposure. A denial that is too broad can force opposing counsel to test its limits. A claim of separation can prompt questions about shared timelines, shared spaces, or shared knowledge. None of this implies guilt, it implies relevance. And relevance is enough to expand inquiry. The mismatch between public confidence and legal caution is common but dangerous. In public discourse, certainty is rewarded, ambiguity looks weak. In court, caution is often safer. Lawyers hedge, qualify, and preserve optionality for a reason. Once a position is locked into the record, retreat becomes difficult. Adjustments look like contradictions. Clarifications look like corrections. This episode highlights that mismatch. What played well as a media posture dismissal, certainty, dominance, does not translate cleanly into legal resilience. The legal system is indifferent to narrative control. It is concerned with coherence across documents, not applause across audiences. Melania's filing, though measured, interacts with that broader media history. It cannot erase it. It becomes part of the same evidentiary ecosystem, where statements echo and intersect whether intended or not. That is the core lesson. Public relations aim to end conversations. Legal filings begin them. One seeks closure, the other invites process. When those instincts collide, the courtroom always wins. What plays well on TV can fail on paper. There has been no dramatic testimony, no explosive hearing, no viral moment that signals a turning point. On the surface, nothing appears to be happening, but that is precisely how the pressure builds. The lawsuit moves quietly through filings, motions, and procedural steps that rarely generate headlines. This is not a case driven by spectacle. It advances on schedules, deadlines, and rules that don't require public attention to remain effective. Progress is measured in access, not applause. Donald Trump's silence in this environment is deliberate. Engaging publicly would risk formalizing positions. Responding legally would lock language into the record. By staying quiet, he preserves flexibility. Silence, in that sense, is a strategic choice, but it is also a risk. In court, silence does not freeze a case. It allows the process to continue without interference. Arguments are shaped by the filings that do exist. Narratives are built from what is on paper, not what is said on television. When one side refrains from engaging, the other side's framing gains space to solidify. Melania Trump's filing alters that balance. Her legal response introduces new language into the record, language that interacts with existing claims, whether intended or not. It narrows some interpretations while widening others. What was once a single track becomes a shared legal environment, where proximity and consistency matter more than volume. Meanwhile, public attention remains fixed on Epstein as a figure, not on the mechanics of the case. The focus stays on names and associations, not on how procedure quietly expands relevance. That gap between perception and process is where legal pressure accumulates. There is no announcement when the trap closes. No dramatic moment marks the shift. Deadlines pass. Motions are granted. Scope expands incrementally. By the time consequences become visible, the structure has already taken shape. The danger here is not confrontation, it is accumulation. The trap wasn't loud, it was procedural. Why this case won't go away? There is no verdict, no courtroom climax, and no clear end in sight. Yet the case persists. That is not an accident. It is a feature of how Epstein-linked claims tend to operate once they enter the legal system. Cases tied to Epstein resist closure because they rarely hinge on a single allegation. They exist as clusters of claims, references, and prior reporting that courts must address piece by piece. Even when individual assertions are challenged, the surrounding context remains active. Resolution becomes procedural, not decisive. Michael Wolff's filings reinforced that dynamic. Each motion keeps the matter alive without requiring a dramatic revelation. The claims don't need to be proven immediately to remain relevant, they only need to be arguable enough to stay before the court. That threshold is lower than public perception often assumes. Trump's name intensifies the effect. High profile figures act like gravity wells in legal disputes. Attention, scrutiny, and interpretation accumulate around them automatically. Even indirect mentions gain weight simply because of who is involved. Melania Trump's filing appears designed to close the door. Legally, it seeks distance and clarity. But courts move slower than public attention, and attempts to seal narratives often extend their lifespan. Unresolved stories don't disappear, they linger. You don't need a verdict to stay in the spotlight.